Strike and lockout, two different subjects. One is the weapon for the workman, the other one is the weapon for the employer. Now, the beauty of these two subjects is they are going hand in hand. Yes, I meant it. The chapter 5 and 6, which are discussing about the strikes and lockouts and the penalties, both of them are going in the same sections. They are traveling together and they are almost like copy paste. If you understand one, in the same section there will be the discussion on other one also, and it is quite similar. If you have already gone through my presentation on strike, you will feel like this is a copy paste presentation. Yes, you are almost right because the provisions are almost right. Except for the definition, everything else are going with the same chapter with the same sections. Hey guys, welcome to my legal classes. This is Ganesh Pujari, and after my last class, that is strike, today I am going to discuss all provisions related to lockout along with case laws. Why to waste time? Let's get into the first slide. First thing first, let us try understand the meaning of lockout, which is given under section 2(1), which says lockout is the refusal by an employer to continue to employ any number of persons employed by him by temporary closing of a place of employment or the suspension of work. Now, what is the requirements? There should be an employer and there should be few employees. Now, basically this employer has given employment to those employees, but now that he is refusing to give them employment, maybe by temporarily closing of a place of employment or by suspending the work for temporary time being. Now, that is known as lockout as per section 2(1). Few of the important aspects that you need to remember as far as lockout is concerned, I have given here in the yellow box. Remember that the lockout is not a permanent dismissal or discharge or retrenchment or termination of employee. It is temporary in nature. The refusal of employment or the temporary closing of a place is of temporary in nature. This is not the closure of business. This is the temporary suspension of work or temporary closing of a place of employment. And the refusal of employment here is also not permanent in nature. It is for temporary nature only. And once such lockout is over, the employees will get back their job. That is very important aspect you need to remember. And just like strike is a weapon available with the union or the workman, the lockout is the weapon that employer uses to satisfy his demand by the workman. Now, when employees have demands, they do strike. Likewise, when employer has certain demand, he can call for a lockout and make his employees to agree with him. So this is the weapon which is available with the employer. Then comes the two important sections, section 22 and 23, which are discussing about prohibition of lockouts and strikes. I have very clearly explained these two sections while explaining strike, and here also I will do the same thing. This is almost a kind of copy paste, but let's try understand the concept very clearly. Section 22 is prohibiting of lockouts for the public utility services. Now, subsection 2 of section 22 says, which I have kept in green box, no employer carrying on any public utility service shall lock out any of his workmen. So, you need to understand that section 22 is applicable for the public utility services only. And it says, no employer carrying on any public utility services shall lock out any of his workmen without considering the four other subclauses which are given here in the black boxes, that is A, B, C and D. If you have already watched my video on strike while explaining section 22 subsection 1, there were four subclauses, that is A, B, C and D, and here also under subsection 2 there are four subclauses and they are copy paste subclauses. I have told a very clear story while explaining section 22 subsection 1, and I will repeat the same story here also. Now, there are four subclauses A, B, C and D. I am not going to explain A, B, C in sequence. I am explaining them together. Now, imagine an employer want to do a lockout. First thing in public utility service that he has to do is he has to give a notice to the workman, and in the notice he has to mention that on what date he is going to do the lockouts, or on what day onwards he can do the lockout. That is the first requirement which is discussed here in subclause C, which is mentioned as expiry of the date. Now let's have an illustration. Imagine an employer want to do a lockdown on 20th January and he is giving a notice on 1st January. So while giving the notice on 1st January, in the notice he has to mention that he has the intention of locking down the place of employment on 20th of January. Now till 20th of January he cannot close his factory. That is a very clear understanding we need to have. Only after 20th, on 20th or after 20th, he can close down the place of work. It may be a factory or establishment whatsoever. So he cannot close till the expiry of the date which he has mentioned in the notice, that is discussed under subclause C. Now what does subclause B says? It says there should be minimum of 14 days before such lockdown. Now for example, if he is giving notice on 1st January, he cannot close at least till 14th of January. That is a very clear requirement as per subclause B. Then comes subclause A, which discusses about the validity of the notice. Now what happened? He gave a notice on 1st January. Now that we know he cannot lock down the place till 14th of January, and he has mentioned that he will do such activity only on or after 20th of January. So as per subclause C, he cannot close the factory or such workplace till 20th of January. That is very clear. Now how long is that notice valid? That is very important aspect which is discussed under subclause A, as it is valid for 6 weeks only. Now what is 6 weeks? 6 weeks into 7 days, that means 42 days. That means if he is giving notice on 1st January, the validity of the notice is only up to February 11th. That day it becomes 42 days, and February 12th onwards he cannot do any lockout with that notice. If he further has any intention, then he has to give a new notice. I hope that is very clear. So you understood that there should be a notice. That is the first requirement. In the notice he has to mention a date of intended lockout, and he cannot do lockout till that date. Along with that, such minimum notice should be of 14 days. First 14 days he cannot do lockout. If he is giving a notice on 1st January, his intended date can be the earliest on 15th January, nothing before that. And any date that he has mentioned, till the expiry of that date, he cannot close down such workplace. And then the validity of such notice is only 6 weeks. After that, if he wants to close the place, then he has to give a fresh notice. That is about subclause A, B and C. Now what does D says? During the pendency of any conciliation proceedings before a conciliation officer and 7 days after the conciliation of such proceedings, there cannot be any lockout. If there is any conciliation proceeding in progress till the conclusion of such proceedings, and once the proceeding is concluded, for next 7 days there cannot be any lockouts. That is as per subclause D. Now before furthering anything on prohibition of lockouts, we also need to understand why does lockouts happen. I have given the answer in yellow box that can fit anywhere in your answer. You can utilize the same. Like the reasons can be industrial disputes with employees, or continuous disputes among the workmen themselves, or the illegal strikes, regular strikes or continuous strikes by the workmen can also cause lockdown, and too much of external interference like the external unions bothering etc. can also cause lockout. Likewise, the failure in maintaining proper industrial relations, industrial peace and harmony can also cause lockouts. Now in the next slide, I will explain little more about section 22. So few important things as far as section 22 is concerned. In any lockout which is happening in public utility services, the minimum notice that employer has to give is 14 days and the validity of the notice is 6 weeks only. And in the notice they have to mention when the lockout starts. There is no requirement of mentioning that how long lockout goes, and if the lockout is not started within 6 weeks, then they have to give a fresh notice. They are the first 4 points. Now let us try understand section 22 subsection 3. If there is already a strike in progress, in that case a notice of lockout is not a necessary requirement. However, if he has any such intention, if the employer has any such intention, he need to give the information to the appropriate government. Likewise, section 22 subsection 5 says a notice shall be given in such manner as may be prescribed, and once such notice is given, then comes the duty of the employee or the union. As per section 22 subsection 6, they have to give the copy to the appropriate government within the 5 days of receival of such notice, and that is all about section 22. Now let us try understand prohibition of lockout under section 23, which is applicable for both public utility services as well as other industries. Section 23, as I have already told, it is general prohibition of lockout which is applicable to public utility services as well as all other industrial establishment. It says no employer of any such workman shall declare a lockout in 4 different scenarios. What are they? A. During the pendency of conciliation proceedings before a board and 7 days after the conclusion of such proceedings. Now, if there are any conciliation is in progress with the board, during that time there cannot be any lockout, or after the proceedings are over for next 7 days also there cannot be any lockout. Likewise, under B, during the pendency of proceedings before a labor court, tribunal or national tribunal and 2 months after the conclusion of such proceedings. Now, a proceedings was in progress with a labor court or tribunal or national tribunal. In such case, while the proceedings are in progress, there cannot be any lockout, and then after the conclusion of that, for next 2 months also there cannot be any lockouts. Likewise, during the pendency of arbitration proceedings before any arbitrator and 2 months after the conclusion of such proceedings, there cannot be any lockouts. And finally, during any period in which a settlement or award is in operation in respect of any of the matters covered by that settlement or award, there cannot be any lockout. Imagine there is a settlement or award in operation, and during such time, if there are any matters related to the topics that are covered by the settlement or award, in that case there cannot be any lockout till the expiry of those points which are covered by those settlement or award. I hope that is very clear. Now, you might be having one question that under public utility services there is a notice, but among other industrial establishments there is no notice as such. How are the industries managing, or how are the employees managing, or how are the unions are managing? Now, it is not easy to do lockout just like that. For that, what they are doing, under the certified standing order, they will have a clause for the number of days of notice for lockout as well as strike. That information I have given in yellow box. You can just read it and keep in your mind. It is covered under certified standing order of the company. Most of the companies are keeping it as 14 days, just like public utility services, that they will have the clause that for strike, the workman or the union has to give 2 weeks notice. Likewise, for the lockout, the employer has to give 2 weeks notice to the workman. That is the arrangement they are doing there. That way, they are taking care of the minimum timeline. That is one another point that you can remember. Then comes the very important section, that is section 24, which discusses about illegal lockout. Under section 24, there are 3 important subsections. Subsection 1 discusses here about what is an illegal lockout, and 2 and 3 are discussing about what are not illegal lockouts. Let us first try understand what is an illegal lockout. Now that we have gone through 2 important sections which are discussing about prohibition of lockouts under section 22 and 23. There we have seen 4 subclauses each. If anybody breaching that 4 subclauses or total of 8 subclauses, then it is a illegal lockout. Now the employer has to follow them. If the employer is not following them, then they are illegal lockout. Now you need to remember section 22 is applicable for public utility services only, whereas 23 is applicable for public utility services as well as other industrial establishment. Now they have to follow the total of 8 subclauses there. First 4 under 22 and then 4 under section 23. Now the second important thing is there is section 10 subsection 3 and section 10A subsection 4A, which are also defining what are the requirement for lockouts. Now if there is any prohibition by the appropriate government when an industrial dispute is referred to a board, labor court, tribunal or national tribunal, even after such prohibition by the appropriate government, if any employer declares lockout, that is an illegal lockout as per subsection 3 of section 10. Likewise, if there are any reference made to the arbitration, and when such reference is made to the arbitrator and the appropriate government has given a notice that there cannot be any strike or prohibited the continuance of any strike or lockout, and even after having such notice, if any employer is going for lockout, then that is also is an illegal lockout as per section 10A subsection 4A. I hope that is very clear. The next two sections, that is subsection 2 and subsection 3, are discussing about what is not an illegal lockout. Imagine there is already an industrial dispute and as a result of that a legal lockout is in progress. After that, if there is any reference to the board, arbitrator, labor court, tribunal or national tribunal, and if they are starting the proceedings, there the lockout will not become illegal. It can continue because it was already in progress. That is not an illegal lockout. That is the first thing, and it can still continue. Likewise, if a lockout is the result of illegal strike, in that case a lockout cannot be declared as illegal lockout. Now when an illegal strike is in progress, as a result of such illegal strike, if there are any lockout, then they are not illegal lockout, which is what discussed under subsection 3 here. Now let us try understand certain punishment provisions. Here there are 4 sections, section 25, 26, 27 and 28. Section 25 is the part of chapter 5 which is about strikes and lockouts, whereas section 26, 27 and 28 are coming from chapter 6 which are discussing about penalties. Now first let us try understand what is section 25. It discusses about prohibition of financial aid to illegal lockouts. Now imagine there is an illegal lockout is in progress, and if any person knowing that it is an illegal lockout, even after knowing, if he is spending or applying his money, then it is a punishable offense. Now what is the punishment? That is discussed under section 28, which is about penalty for giving financial aid to illegal lockouts. Here, even after knowing if somebody is spending or applying their money towards an illegal lockout, then the punishment can go up to 6 months of imprisonment or fine of ₹1,000 or both. I repeat, I just discussed section 28 because it is the continuation of section 25. Now let us try understand section 26 and 27. Section 26 is about penalty for illegal lockouts. Any employer commencing, that means starting or continuing any kind of illegal lockouts, is a punishable offense, and the punishment can go up to 1 month of imprisonment or fine of ₹1,000 or both. Section 27 is about penalty for instigation, etc. Now, if anybody instigates or incites or takes part in illegal lockout, it is a punishable offense. And remember, here the punishment is much severe comparing to section 26. What is the punishment here? It can go up to 6 months of imprisonment or fine of ₹1,000 or both. These are the punishment provisions you need to remember as far as illegal lockouts are concerned. Now let us try understand few important case laws, and the first case law that I am bringing here is Management of Karibetta Estate versus Rajamanikam and others. Here in this case law there were a lot of discussion on strike, lockouts, layoff, closure, etc. And while discussing, they held that there are two parties and they got two weapons. First, the workmen, they got the weapon of strike. Likewise, the employer got the weapon of lockouts. That is what discussed here in this case law. The second case law that I am discussing here is Tata Iron and Steel Company Limited versus their workmen. Here in this case law, it was held that mere refusal to give employment is not lockout. To consider something as lockout, there should be certain demand or demands by the employer, and only when such demand or demands are not satisfied, if the employer is temporarily closing the workplace or refusing to give employment, then only it is considered as lockout, which is what held in this case law. If somebody is just refusing to give employment, that cannot be straight away told as lockout, which is what held here. The third case law is Indian Marine Services Private Limited versus their workmen. In this case, it was discussed what are the impacts of lockout as a result of illegal strike. Remember, if a lockout is a result of illegal strike, then it cannot be considered as illegal lockout. That is the first thing. Then the workman cannot ask for any kind of back wages for such illegal strike. That is very clear. Such illegal strike as well as lockout. That is what held here. The fourth case law is Lakshmi Devi Sugar Mills Limited versus Ram Sarup and others. Here it was told that lockout is a security measure for the employer. Just like the workmen have strike as the security measure for their requirements, the employer also have a security measure, and that is lockout. That is what held here. The last case law is Mysore Wine Products and Allied versus Presiding Officer, where the liability of employer discussed, and it was told that the liability of the employer will be decided only on the basis whether such lockout is justified or legal or not. It will be not just like the pay which will be given after the layoff. The compensation will not be calculated that way. It will be calculated only after deciding whether such lockout is justified or it is legal or not. That is what held here. With that, I am concluding this particular session. What next? I seriously don't know. I have this many number of requests from the students and I am trying to accommodate one by one. And if I am not addressing any of your message, it doesn't mean that I am ignoring them. I am just trying to bring them all one by one, and I also have a time frame. Trying my best to bring as many as topics possible. Thank you so much for all love and gratitude that you have expressed via your comments. Please subscribe my channel if you are yet to subscribe my channel. Like, share and comment my videos. All the very best for whatsoever purpose you are referring my channel, and thanks again.